Howdy, my name is Brian Foley, and I'm a criminal defense attorney in Houston. I'm the managing partner at Houston Criminal Defense Attorneys, PLLC. Today we're going to be discussing Texas Code of Criminal Procedure, Article 1.051, the right to representation by counsel. And so there's a lot of questions that go on with this. We're going to answer some of them. First, it starts off by saying a defendant in a criminal matter is entitled to be represented by counsel in an adversarial judicial proceeding. The right to be represented by counsel includes the right to consult in private with counsel sufficiently in advance of the proceeding to allow adequate preparation for the proceeding. Typically, that means 10 days. There are other ways that the court will appoint attorneys. For example, in Harris County, there is an entire court-appointed attorney system that happens, and the public defender's office actually appears at what they call PC court every day, about every 2 hours, every 3 hours or so. They have probable cause court. The DA's office has a lawyer there, and the public defenders will talk with you briefly if you've been arrested and argue for you to have a low bond. When you get out of jail, then you can hire a private attorney like us here at Houston Criminal Defense Attorneys, PLLC. But the public defender's office does a nice job there for those initial hearings. Unfortunately, not everybody gets appointed an attorney from the public defender's office. You may get just a regular appointed attorney after that, and so that's where we can come in as well if you'd like to retain an attorney. So this part of the Code of Criminal Procedure 1.051 grants this right of representation. So in Harris County, they have to appoint you an attorney by the end of the first working day after the request for that attorney is received from the defendant. In smaller counties where they have less than 250,000 people, the court has until the end of the third working day after receiving the request from the defendant. What happens if you are arrested in another county? If you're arrested, let's say in Dallas for a warrant out of Houston in Harris County, then the court in Harris County is supposed to appoint you a lawyer immediately. If they fail to do so, then Dallas County has to appoint you a lawyer after 11 days. Dallas County can then request reimbursement from Harris County under those types of circumstances. So what types of proceedings, if you were paying attention when we read the statute, it said for adversarial hearings. Well, every indigent person has the right to be represented by an attorney in the case against them, but that is broken up into different parts. So like the guilt-innocence phase or the trial, that trial isn't going to happen for a very long time. So you have the right to an attorney at critical stages. You also have the right to an attorney after the case is over. If you go to a jury trial and you lose the jury trial, for example, you have the right to a court-appointed attorney after an appeal or for an appeal if it's your first appeal. You don't have a right to one, for example, to petition the Court of Criminal Appeals, the highest court for criminal cases in Texas. They won't necessarily appoint you an attorney for that, but they will for your very first appeal. If you have been denied an attorney by the court or would like to hire your own, regardless of the determination of whether or not you can afford one from the court, then the court only needs to give you at least 10 days. So they could make it very short. They mostly give you more than that, but the code requires them to give you at least 10 days to prepare for any hearing. And we call this kind of the 10-day rule. This is often used by lawyers when we substitute in for another lawyer on a case. We need to get at least 10 days to review the case, get up to speed on it. You can also waive your right to an attorney and represent yourself. This is always a bad idea. I've never seen this go great for anybody with any level of case other than maybe a Class C traffic ticket. But even in those cases, a criminal defense attorney can help sometimes quite a bit, especially if you have like a special type of driver's license. But there is a court case from the Supreme Court of the United States called Ferretta versus California, and in Ferretta, the court held that the Sixth Amendment right to the assistance of counsel implicitly embodies a correlative right to dispense with a lawyer's help and represent yourself. And so we will have, from time to time, if somebody doesn't want a lawyer's assistance, we'll have a Ferretta hearing. And that is normally bad news for the defendant, because if you're having a Ferretta hearing in your case, that means you're trying to discharge your lawyer, You're trying to represent yourself, and the court is then going to hold you responsible to know all the rules of evidence and procedure, and basically act as your own lawyer. And so there's a lot of ins and outs to being a lawyer, especially in a trial. These normally happen right before a trial because the state often will not negotiate with somebody who is not represented by a lawyer. And so we have a form, actually, with this decision in the Ferretta case in mind. The legislature crafted a form which they have included inside the Code of Criminal Procedure, and it says, if a defendant wishes to waive the right of counsel for purposes of entering a guilty plea or proceeding to trial, the court shall advise the defendant of the nature of the charges against the defendant, and if the defendant is proceeding to a trial, the dangers and disadvantages of self-representation. Basically what I just said. If the court determines that the waiver is voluntarily and intelligently made, the court shall provide the defendant with a statement substantially in the following form, which if signed by the defendant shall be filed with and become part of the record. The clerk would keep that. And so here's what the form says. Quote, I have been advised this whatever day of whatever, 2000 whatever, by the name of court, and you insert the district or county court's name, of my right to representation by counsel in the case pending against me. I have further been advised that if I am unable to afford a counsel, one will be appointed for me free of charge. Understanding my right to counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request for the court to proceed with my case without an attorney being appointed for me. You see why they're making you do this? This is the same reason why a company makes you sign a bunch of papers right before you jump out of an airplane without a parachute, or even with a parachute, This is dangerous. Don't do it. But we told you not to do it. We told you we'd give you a lawyer for free, but you want to do it anyway. That's what you have to do. That's how strong the right to counsel is. And, that's most of the ins and outs of this particular law. I hope you've enjoyed today's video, and we'll see you next time.